The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good evening, and thank you for spending a portion of your evening with us. One case will be submitted this evening. That case is Danny Homan, Stephen J. Sodders, Jack Hatch, Pat Murphy, and Mark Smith versus Terry Branstad, Governor, State of Iowa, and Charles M. Palmer, Director of the Iowa Department of Human Services. This is the time set for the arguments in the case, and Mr. Thompson, you may proceed.
May it please the court. On August 20th, 2013, Governor Branstad issued Executive Order 82. He issued this order in response to concerns about the conditions and care of children at the juvenile home in Toledo. As he began the process of seeking recommendations about what to do at the juvenile home, he reiterated the fundamental proposition of juvenile law in Iowa, which is protecting the health, safety, and welfare of Iowa children. In October, the task force that he formed issued a report. Again, the focus was on the best interests of the children, and the task force made sweeping recommendations about changes that needed to occur in order to serve those children. On December 9th, 2013, in response to the report, DHS Director Palmer announced and made a public announcement notice that the DHS had begun seeking court approval for alternative placements for the children. Again, following Iowa code that requires court approval and the standard being the best interests of the children. He also announced that as of January 16th, they anticipated the placements to be completed and there would be layoffs at the facility. He noted that at the time of the order of the notice that there were only 21 girls still being served at the juvenile home, which had a capacity of over 50, and there were 93 full-time employees served.
Are we really here to deal with the merits of the case, or are we really here to decide whether or not the preliminary injunction should have been granted and the other issues surrounding that?
I think the answer is yes. You know, the order that we're here to deal with is Judge Rosenberg's order that both granted a preliminary injunction and denied a motion to dismiss.
Well, what's the effect of the defunding that occurred in the legislature?
In the subsequent fiscal year? Well, I mean, I think it does two things. I think there's a part of the order that is just moot because the order says give access to the funds that were appropriated during that fiscal year. But it doesn't moot the part of the order that says reopen the juvenile home, which is one of the things he did. And in fact, what it does is it reflects that the legislature essentially has now ratified what the governor did. And so now there's a juvenile home and there is funding. There's $500,000 a year and 2 FTEs to keep it safe. And the legislature rejected an attempt to make a full appropriation for funding to operate it at full levels. And so, in effect, the legislature came back and ratified what the executive decided to do in response to the task force report.
Mr. Thompson, why isn't the whole thing moot if the legislature has only appropriated enough money to essentially preserve the building at this point for this fiscal year?
I mean, one could argue that it's moot. The trouble that at least we have with the mootness argument is, again, if this appeal were dismissed, an order would stand that says reopen the Toledo.
We could vacate the order as part of a mootness ruling, conceivably.
If we win, that's correct.
Well, we could conceivably hold that the issue is moot and that the district court's order should be vacated because it's now moot. I mean, it seems to me this is a fight about money, as correct me if I'm wrong, as I know you will. And the legislature going forward has clearly expressed its view, and as to any money that was remaining in a prior appropriation, it reverted to the general fund, I take it?
Yes, sir.
And so I'm not sure we have a real live controversy here to decide.
As to that aspect of the case, I think I agree that you could find that it's moot. You could dismiss it and dismiss the entire action as moot. There's obviously an exception to the mootness doctrine, and one of the claims, one of the issues here that's been raised is a case of first impression that deals with an important constitutional issue, and so one could argue that issue still is capable of repetition.
We're not going to reach the constitutional issue because the only issue before us is the temporary injunction. We're not reaching the merits of the case. So if let's assume the case is moot, then why should we reach the temporary injunction issue if the case is moot and there's no controversy left? I mean, I don't know. Tell me why we should even get to the merits under the posture of the case, even if it's not moot. Because really we're dealing with whether or not the temporary injunction should have been granted, not the merits of the case.
I think you're correct on both counts. I think that this case could well be viewed as moot by this court, and if you view it that way, that you could dismiss the action, vacate the order, and we'd be done with it. As to the second part of your question, we agree that you don't have to get to the merits of this faithful execution argument to simply vacate the injunction and send it back, because we think that on the injunction, the well-established law of the injunction, that the court abused his discretion in entering an injunction that had no factual basis, that was on a contested, unsettled question of law, and literally destroyed the status quo for all those reasons.
If we lift the injunction, what's left to try if there's no funding for the institution?
I mean, there is funding for the institution. There's an institution with caretakers, and the real issue, and maybe I can answer your question a different way. I don't think we disagree that what happened here is this case, in essence, although couched in terms of a over money and over funding, was really a challenge to the decision by the Department of Human Services to seek alternative placements for these girls. I mean, that in the end, that's what happened. I mean, that's why it's consistent with the statute anyway, because there's no need to fully fund an institution when there are no girls there, and that's really the core of this thing, and that's what happened. During the ending part of the fiscal year, although they had spent a significant amount of the dollars, they continued to spend money all the way to the end of the fiscal year, and then the legislature reset and said, we are going to further reduce the appropriation and put the facility into a caretaker status.
Counsel, doesn't the fact that this is presented as a question of first impression suggest it's not a recurring issue? We've never seen it in over 100 years.
Yes, I think you're right about that. I mean, I guess it's capable of repetition, but it certainly is. This is the first rodeo for it.
So this would be a poor candidate to fall into an exception to the mootness doctrine, right?
I think that's right.
If we do reach the merits, are there decisions from other state Supreme Courts that support your position? Because we didn't see any in your brief.
Well, I mean, if you reach the merits, I actually think that the cases relied upon by the district court and by the plaintiffs actually are supportive of our position on this set of facts. In other words, this idea of an unconstitutional impoundment, really, when you look at the authority that's relied upon by the plaintiffs, focuses on the way the process plays out, and there has to be essentially some motive to circumvent the process or to undermine the fundamental purposes of the statute. And we would argue that in this case, in part because the way the process started, that's exactly what Governor Branstad was trying to do, was to honor the fundamental purposes of the statute and look out for the kids, that these aren't jobs bills. These are to provide services to the children who are committed by courts to the facility, and that just doesn't exist right now.
This seems to be an argument between the governor and the legislature about spending an appropriation. Why should the courts get in the middle of it?
Well, in this case, I don't know that the court should. I mean, you've talked about mootness. As we've raised in our brief, we raised below, there's a serious standing question here about whether the people who've brought this claim are the right people to bring this challenge before you. And in the Godfrey case, for example, this court pointed out that when you're being asked to pass on the constitutionality of the conduct of another arm of government, you should be very cautious about accepting broad arguments about standing.
On the standing question, though, haven't we consistently found in the line item veto context that a citizen taxpayer has standing?
You have, but
And how is this different, at least from a standing perspective? How is this different?
Well, I think the standing argument in a line item veto case, when you look at the nature of that case, it is a procedural case in essence. And so we've got the Rance case, for example, where we find legislative standing, and you've got the Turner case, which arguably is broader, perhaps taxpayer standing. But in the end, it's a question about the process that leads to a law or
Well,
something.
this is a question about the process too, and what's at stake is whether monies appropriated by the legislature should be spent. I mean, the item veto case, the legislature passes an appropriation, the governor attempts to veto. The battle is about money ordinarily, or a condition, and we allow taxpayer standing, and kind of broadly so, I think. It's a little hard for me to understand why, in this case, standing for taxpayers wouldn't also apply.
Here's why I think it should be, because the nature of the faithful execution claim is different than the item veto cases, in part because everybody agrees, especially under this statutory scheme and the language of the statute, that the executive has authority and discretion to spend up to an amount or even spend less if the motive and the intent is that they can faithfully execute the law, if they can fulfill the purpose of the legislation by spending less. If you look at the impoundment cases that find otherwise, it's always couched in a fiscal battle where the executive tries to achieve through failing to spend.
But isn't that an argument on the merits, Mr. Thompson? I mean, it strikes me in the line item veto, the argument is that the governor is thwarting the legislature's intent through the misuse of the line item veto. In this context, or thwarting the appropriation, in this context, the claim is that the governor is thwarting the appropriation by impounding money. It sounds like, at least from a standing perspective, it's a similar argument, isn't it? A similar kind of injury, if there is an injury?
Well, I think it's similar, but I think this case illustrates why it should be treated differently. And it's because in the end, you've got to look at the motives of the executive and to see if they're trying to thwart or whether they're faithfully executing. And what you've got
So who would be a proper plaintiff?
I mean, if you look at the Michigan case that's cited by the court and by plaintiffs, it's a great example of the right people. In fact, you've got people who were individual plaintiffs were individual employees who were about to laid off. They were the organization, the union, who represented employees who were about to be laid off. And they were folks that were involved and had a contact with the purpose of the statute, which was the organizations that dealt with the mentally ill.
Those people probably could collect money damages, and you wouldn't get equitable relief. I mean, where there's money damages, there's an adequate remedy at law, and you don't go to equitable relief. Who would have the right to standing to ask for an injunction to, to pursue this lawsuit other than taxpayers?
Well, I actually believe that an employee, if had filed a case prior to the layoff occurring, would have had more than a claim related to simply damages. I
What
think that
about
a patient,
parent of a child?
yeah, a parent or a patient.
Who wanted their child to be at the juvenile home?
Yes,
Would they have standing?
yes.
Let's talk about the injunction a little bit. And I'd like to ask you two questions. First, you've indicated that this is not a status quo type injunction, that it really changes the status quo. But it seems to me the more modern case law suggests that the difference between a status quo injunction and a mandatory injunction has really disappeared. And the notion is that the court has substantial equitable powers. We don't want to have a race to the courthouse. If you get there a day late and somebody locked the door the night before, that shouldn't necessarily, decide the case. If you're trying to keep the forest from being sawed down and one tree got sawed down, that doesn't oust jurisdiction of the court to issue a preliminary injunction. So I'd like you to address that feature. And then secondly, irreparable harm is a significant component of a preliminary injunction, and isn't a ongoing law, alleged ongoing violation of law, irreparable harm?
Well, to the first point, I mean, I agree. First of all, injunctions are in equity, and there's pretty broad discretion in the courts. But they're in equity, which also means that people seeking an injunction can't sit on their rights. That's part of the plan there. And so in this case, for example, plaintiffs had notice for over a month before they filed a lawsuit. And then they filed a request for a preliminary injunction and didn't get a hearing. They had notice for 45 days of the date of the layoffs. In fact, they had time to file a grievance and settle the grievance before they filed the lawsuit and got a hearing. And so in the end, they ultimately had a hearing. And when the hearing occurred, all the layoffs had occurred, all the children had been reassigned, and a court in equity has to balance the harm against the other side. And on these facts, it's really hard to argue. It wasn't a race to the courthouse. There wasn't any sneakiness going on. It was very public. And in the end, everything that they asked to be, done had already been done. And so this order, rather than preserve the status quo for purposes of the litigation. So in the Michigan case, for example, the injunction stopped the layoffs in time to permit the union to grieve and arbitrate the situation. Here they waited till afterwards. And so I think in equity, yeah, I agree that the court has discretion. I think on these facts, the court abused their discretion by trying to unravel something that was really completed. Remind me your second part of the question. Well, most of your constitutional law that presumes irreparable harm for a constitutional violation is First Amendment law and things where somebody's rights are really being infringed. Here's a kind of a theoretical separation of powers issue, and I think the irreparable harm component of the injunction law illustrates the standing issue that we've been talking about, which is if you don't have somebody before you that can really say, because the law requires the plaintiff be irreparably harmed, not just somebody. And so the fact that we don't have a plaintiff that could put on any evidence or even argue for irreparable harm suggests that there's also a standing issue that addresses why.
Does it come down to an argument of the best interest of the child then? And that would be open for anyone to argue, wouldn't it?
Well, I think for a child, for a parent, I mean, I think that's a difficult argument to make, that any taxpayer, any citizen in any case that deals with the best interests of a child has standing to be part of that. I mean, I think that these are very important issues, but one would argue that the more important they are, the more important it is to have the right parties before you litigating and making a record about the result. Because here, the question is, did what the governor and Charles Palmer do, undermine or thwart the purposes of the statutory scheme, and you've got to look at the effect on somebody to decide that. And in this case, what they did was in the best interest of the children. And so, in the end, I think you should vacate the order for any one of several reasons at a minimum, and I believe you could dismiss the whole case as moot. Thank you.
Thank you as well, Mr. Thompson. Mr. Hedberg.
When we first got this case, we treated it like a line item veto case by de facto. In other words, we had a governor who was taking money that had been appropriated for one thing and said he wasn't going to spend it, no different than if he'd exercised a line item veto in a proper manner. So I think we have standing just like we did in the veto case.
Agree that the standing doctrine in the line item veto cases, it goes back to 1971 to the first case, but it's never really been explained and analyzed. It's really kind of just a conclusion, right?
I would agree. I would agree that it's been accepted as standing without really getting into the details of why. I would agree with that analysis.
Well, didn't the line item case also deal with a fundamental constitutional issue?
And we believe this is the same thing, a constitutional issue.
Well, why isn't this case more in line with Alon's?
Well, because we believe that it is in line, the Constitution, I guess, refresh me on Alon's, I guess. I'm trying to get through here.
Lons was complaining that we weren't our branch of government was not following the legislature's laws, and we said that was not enough to confer standing on him. Your clients are complaining that the executive branch is not following the law, and why isn't that abstract interest in following the law insufficient under sort of standing
Right, and I would
doctrine?
agree that, yes, it is. We have an interest in following the law, both as legislatures, taxpayers, and residents.
Well, but we don't ordinarily give advisory opinions. There is the exception to mootness doctrine, which, as I view it, it says basically if it's an issue of public importance and there's a four-pronged test, including,
I've got it right here, Your Honor, yeah.
Well, why don't you head into there and convince me that this is an issue of public importance?
It's the Hill case. First, there's an exception, and first is the private or public nature of the issue. This is a public nature.
Can I interrupt for 1 second? Do you concede this is moot?
I don't concede it as moot because we still have an ongoing violation of the Constitution.
Which is what?
Well, he didn't spend the money as he was supposed to. The harm was to the Constitution. That harm still exists.
But in Rush versus Ray, we said once the money is appropriated and the fiscal year is over and the money it reverts back that's not spent, it's moot. I mean, that's what we said back then, and then we made an exception under the public policy.
If you're just looking at the money, but here I'm looking at the violation of the Constitution as a harm too, and that's not moot. That violation still exists. And I think the exceptions really apply in this case because if the executive is always going to have the advantage in terms of getting things done. It takes
the exception wouldn't apply if it's not moot.
Right.
I mean, so you can't have it both ways, but go ahead, answer.
Well,
Justice Apple's
I guess
question. I'm
the four
sorry.
prongs I'd like to get to. It's a public issue. The second prong is the desirability of an authoritative adjudication to guide the public officials in their future conduct. Okay? In other words, does the appellant exist? Yes. If so, you better follow it. The third one is the likelihood of reoccurrence of the issue. And fourth, the likelihood the issue will reoccur yet evade appellate review. And that's what's happening here.
It's only,
Counsel, I'm not sure I follow the continuing nature of the violation, and let me explain why I don't follow it. As has already been discussed, the legislature came along in May of 2014 and defunded the home with the exception of the ongoing maintenance
Correct.
costs. And so in what context do we think it's a continuing violation?
Well, I see the Constitution has been violated, as it's done, it has been violated. That still exists. Whether or not the facility's there or not, I don't think is that important. The question is, did he violate the Constitution when he didn't spend the money as he was told to under the appropriation? If yes, that is a violation.
Let me ask this question, getting to the merits of your argument. I do understand that there was an appropriation of X million dollars, and obviously a significant fraction of that was not spent on Toledo. And you're suggesting the legislature appropriated these funds for a specific purpose, namely Toledo, and that legislative intent was thwarted. But there's another perspective on the case that I want to advance and get your reaction to, and that is this. Director Palmer made the determination that it was in the best interest of these 21 children that they have alternative arrangements other than Toledo. That's an executive type determination, it seems to me, not a legislative type determination. It's based on the facts of each individual case. And then Director Palmer got court orders for alternative placement. The end result was no one was at Toledo. Now, were those actions unlawful?
I believe so.
And why?
Oh, because they were, the money was appropriated to spend it on the number of people. I think they had how many people were supposed to be employed there. All that, and in all of this, I didn't see anything in the study that suggested there was imminent harm going on, that they could have slowed down and done it appropriately, like they did when they didn't appropriate the money.
The courts determined it wasn't in the best interest of the children to keep them there. Obviously, they transferred them out. Why would you pay for something that's not providing any services?
They made the determination that wasn't appropriate because the institution no longer existed, obviously. I mean, they were going to shut it down. He said so in the executive order. So I don't see how you could place them anywhere else, I mean, at that time.
So your petition relies on the task force report, and that's a very detailed, thorough report by some experts in the field. Because your petition relies on it, is it fair game, the contents of that report, for the court to consider and take judicial notice of in this appeal of an injunction ruling?
Well, I guess, what are the merits? Are the merits whether or not there's an impoundment? Regardless of whether or not it was Fort Madison, Clarinda,
or in the best judgment of the executive branch, it was in the best interest of these children to be transferred and for the home to be closed.
But that didn't translate. You look at that report that was done, the study. I don't see anywhere in there that it told them to transfer them out. Matter of fact, it told them to improve it, as I recall.
It left, I mean, it said transfer out the girls who are China, right? Get them out.
Right.
Then it said, as to the delinquent girls, if the facility remains, you're going to have to do something about these residential cottages, because apparently, I haven't been there, but I understand that they're not really secure or able to be made secure, and therefore there was this overuse of seclusion rooms in the main facility.
I don't know if that's why there was an overuse of seclusion rooms. I do know that there were some issues involving electrical wiring at one of the cottages. I recall that. But I don't recall them saying there was no place at that facility for these girls to be in a safe environment.
Can I back you up for a second? You said, and that's my question, what is the merits of this appeal? Is the merits of this appeal, say we get by mootness, say we get by standing, or we have an exception to mootness and we're talking about public importance, but the merits of this case seems to me not whether impoundment's a good theory or a bad theory or things like that, whether or not the temporary injunction should have been issued.
And whether or not the judge abused his discretion in doing that.
Right, and then you have the test that we talked about, you know, irreparable harm. Tell me where the irreparable harm is. Tell me how the things that we look at in issuing a temporary injunction, and to these plaintiffs.
To some extent, the irreparable harm was created by the governor himself when he closed it down. I mean, one of the arguments they made was, well, it's all tore down now, or it's all shut down.
What did he create? What is the irreparable harm?
He created a defunding and closed down a facility. That's the irreparable harm. And by the time we can get that ship turned around, it's too late. That's the problem. It's a constantly, the
Where's
executive branch is
irreparable
always going
harm?
to have the advantage in that area.
How is there still irreparable harm when the legislature didn't fund the institution for the next year to operate as a
Well-
juvenile home?
There's an irreparable harm to the Constitution. That's where the harm is. The law was violated.
But isn't that an academic question when, because of the defunding in the 2014 legislature, it doesn't matter anymore? The home's not funded.
For that period of time, no, it's not funded. But it was funded before that. I mean, if you take it to its logical extreme, any executive could say, I want to not spend any money at Fort Madison and shut down all the institutions if they so desire.
Take your argument one step further. Let's say you win, okay, and you get your trial on the merits. What's your remedy? Because they didn't fund it the year afterwards, so what's your remedy? What would the court order to be done for?
In this case, I
Yeah.
think what part of the remedy may be, we asked for a mandamus to reopen it, to do what they were supposed to do. That isn't going to happen. I understand that. Part of the remedy would be, I suppose there might be, I don't think there'd be money damages available. But I guess what we'd have is a situation, we're back to the exception to the mootness, is at least we'll know what can and can't be done.
The legislature could close this down at any time. Any time they don't budget the money, they can close the facility down, so, and that's where we are today, so.
Yeah, but just because they did the right thing now didn't mean they didn't do the wrong thing before.
You don't get a remedy, you just get an advisory opinion.
Well,
That's what
I don't know,
you're
if
asking for.
I think it's more than an advisory opinion. It's the result of it. He did act unconstitutionally at that point in time. That's for. And I understand our time.
What does that get you? Tell me what it gets
Well, it
your
gets me,
clients for relief.
what it gets me is this, is an understanding in real time what the executive can or can't do next. And I can tell you right now, we have Cherokee, Independence, Clarinda. Those are being shut down. There's funding for those. That's a real thing happening. And maybe they'll work it out. I said, theoretically, I could bring a lawsuit on that right now. As similar things happen in there. It says there must be these institutions at these particular cities. So it is reoccurring.
Even if it's reoccurring, we often say it has to be reoccurring yet evading review. In this case, if it evades review, it's only because we have perhaps the unusual situation that the legislature went along with the governor the following fiscal year. That's not always going to happen.
Well, it evades review because the executive branch can act faster than the judicial. That's how it evades review.
Oh, no, if the legislature had stuck by its guns for the 2015 fiscal year, the case wouldn't be moot, right?
Not necessarily. He could have vetoed it.
Well,
Right?
well, but
I
then
mean,
it doesn't become law. I
Right,
mean,
right,
then
right.
the point being, if the legislature had stuck to its guns and had the votes to continue to impose its will, the case would not be moot, right?
Correct.
But because the legislature and the governor agreed in 2014 to defund it, aren't you now asking the court to second-guess the two elected branches of government?
To ask the legislature what they thought after it was already shut down as opposed to before it was shut down is a whole different question. I mean, once the cows are out of the barn,
This happens in government all the time, that the legislature appropriates money for different uses. They don't spend it for some reason, and the money goes back to the legislature. It happens in maintaining the roads, in maintaining the bridges. It happens in law enforcement. It happens all through the government where the executive branch makes a decision how to operate with that money and doesn't spend it. So I think you're telling me that unless they spend every penny appropriated the way it's supposed to be, then you could bring a lawsuit to make sure they spend the money.
that's not what I'm saying. What I'm saying is the exception in this case swallowed the rule. You know, it's one thing to say, I don't need 100 people here or $1 million. Another thing to say, you don't need any. In other words, the purpose of that facility by his not spending the money been defeated. That is, to be a training school.
Don't they close like Iowa State patrol posts over the year? They may close one down because it's more efficient. They have 4 districts instead of 6 districts. They close maintenance facilities all the time for the highways. And what I think you're telling me is when the executive branch or the departments makes those decisions to do it, we should have a lawsuit to come in here and say, well, you should have kept that maintenance facility open or that patrol post open.
I don't think they're identified in the appropriations like they are in this case for a specific facility.
Are you suggesting that if the facility had stayed open and there had been one child client, that then that would have been okay?
Not necessarily, no. I mean, by the time, what I would suggest is that he shouldn't benefit from his own unconstitutional act, which is to shut it down de facto, when he couldn't do it legally.
But I want to push back a little bit, and that is that, you know, Mr. Thompson, of course, suggests that what was at stake here was the best interest of the children. And I think there's a whole nest of statutes that deal with that, of course, and we all embrace it, and I know you do too.
Right.
And one way of viewing this case is that the governor had the executive responsibility and his director of Human Services to take action that was in the best interest of these troubled kids, and the facility just wasn't doing it. And although there was money available from the legislature, the responsible executive authorities just decided that the legislative goals as reflected in the various sections of the code dealing with children were not being advanced by keeping people at the facility.
Again, that's the underlying merits of whether or not you keep it open or not to be decided by the legislature and their appropriations. I mean, that decision was already made by the legislature the year before when they funded it. They made that decision. And he, on his own, I guess I see my time's up, but thank you very much.
Thank you, Mr. Hedberg. Mr. Thompson, you may present your rebuttal argument.
Just a couple of points. On the standing point, I mean, I do think that Appellants is on point, and it's the right standard here. And I think that this court in the later Godfrey decision really reiterated the same test that Appellants applied. In Godfrey, this court, as to taxpayer standing, said nothing more than a general vindication of the public interest in a government branch acting in conformity with the Constitution is not enough, that there needs to be a personalized injury. And I think there's a reason for that, and I think it was well articulated by this court in the Godfrey decision. And I know that Justice Wiggins and Justice Heck disagree, and but even in the dissent, you qualified it as not just any constitutional claim, but something that really was fundamentally urgent, and I think this isn't that case. On the question of judicial notice, I do think the task force report is in play, fair game here, because I think it was, again, referenced in the complaint. It was referenced in Danny Homan's affidavit. It was actually referenced in Chuck Palmer's of the notice that's in the record. There was a website link to the task force report. It's a public document. It's available on the website. I think it's fair game. And if you have to look at, if you're inclined to look at the merits of the case, it is critical to understand from that report the motive of the executive here. It wasn't like those cases that get cited in impoundment law where there was a 1 or 2 year fight over a budget, and the governor loses, and then he just tries to do exactly the same thing by impounding X dollars that then matches miraculously up with the budget that they tried to pass in the first place. Nothing could be further from the facts of this case. And the report also reflects that although, yes, there was money available and they had to make decisions based on the best interest of the children, in the end, one could read that report and conclude that one alternative here is that there was money available, but there wasn't enough money left in the bank to do it right. And that was an executive decision that needed to be made.
Why wouldn't the governor just veto the bill when it was brought up rather than go through this this process of signing the bill and then midstream saying, well, I didn't like the funding for it, it's not really working, so I'm gonna do something else.
Well, but that illustrates my point. If you read the impoundment cases, that's the fact scenario. You have a budget fight, governor loses, and then he tries to. Here, there wasn't a fight on the funding of the Toledo home at all. There was funding, it was appropriated, there were 114 FTEs, but something happened after that. And you guys read about it in the paper. I mean, there were all kinds of complaints and concerns about the care and treatment of those girls. That's what led to the executive order. That's what led to the task force. That's what led to the facts that led to this case. And it's not the governor just deciding he wants his way on budget matters. He had to make tough decisions to respond to an urgent need that was consistent with the statutory scheme for juvenile law. And so I think that very question illustrates that that's not what we had here. There's nothing in the record to suggest this is a stalking horse for a budget fight. In fact, there was no budget fight on the front end. These were circumstances that came to light after the appropriation bill. Justice Wiggins, you asked about, well, what is the analysis if we get to the meat of this thing and we get past mootness and we get past standing? I think the answer is, under Rule 1502, there's got to be a factual basis to enter an injunction, and this record is empty. We had an evidentiary hearing where the plaintiffs offered no evidence. And in the end, we made the tough decision to put some affidavits in the record just to make sure that we could make the arguments that we're making about the best interest of the children. But that's the simple way to get rid of the injunction. It doesn't comply with the rule or the law for requirements of injunction. And then
Do we need to reach the empowerment issue?
No.
If we're gonna get rid of the injunction?
No, you don't. I mean, there are independent ways to get rid of the injunction without even dealing with likelihood of success on the merits. And I think you could even deal with likelihood of success on the merits without reaching the deep underlying merits of the question of impoundment. But that's all I have, unless somebody else has any questions. Thank you.
Thank you as well, Mr. Thompson. The case then is submitted. Before adjourning court, I just want to thank everyone for coming this evening. It's important for our courts to be open and accessible, and also to be witnessed. We can all learn a lot by the way our government operates, and I commend you for being here tonight to witness these proceedings. We'll continue to study the case. We'll render a decision in writing, and it'll normally they come within about 90 days from today, and you can monitor our website as to when it'll be filed. We look forward to joining you in a public reception on the second floor of this building in the Light Court. Thank you again. The bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.